So who is the move-it today?
That would be Plaintiff, Kaden Sanders.
All right, very good. Let me hear from you, Ms. Salinas.
Sure. So we are seeking a summary judgment pursuant to this promissory note between these two individuals. The promissory note does include or liquidated damages. It essentially was a personal loan between these two, partially paid, but the vast majority of it remains unpaid. We submitted the agreement and also communications to prove the amount that is remaining to be paid on the under the agreement.
Okay.
And we are also requesting attorney's fees, and we submitted the attorney fees affidavit to that end.
All right, thank you very much, Ms. Salinas. Ms. Cornblith, let me hear from you.
Okay, well, for starters, plaintiff submitted a business records affidavit, but he is an individual. This is
Okay.
not regularly conducted business. The two parties were in a romantic relationship together. Money was loaned when my client's bank account had some fraud issues. The parties broke up, so Mr. Sanders wanted to be paid back. The parties reconciled. Ms. Orm spent copious amounts of money sending him on trips, doing all kinds of things like that, to where she thought that the note was paid. We've also provided some Zelle payments that he did not account for in his damages. And because of that, we feel that he is not entitled to his summary judgment. There is a fact issue on the amount of damages. And that's all I have for right now, Your Honor.
Thank you. Anything else by way of reply, Ms. Salinas?
The facts that defendant is bringing up raise no material issue as to whether or not there was an agreement. The information that they have provided does not show any agreement as to whatever trips or gifts being part of the promissory note. That was distinct and separate from whatever relationship, whatever funds may have been exchanged throughout the relationship.
Okay.
It doesn't raise any question as to the fact that there is money owed, and I'm not quite sure what the amount of the Zelle agreements doesn't comport, from what I can tell, with the amount that they're claiming was paid off. So what we have shows very clearly an acceptance of the remainder of, I believe it was $17,540 and 32 on the agreement.
Okay. Thank you, Ms. Salinas. Thank you, Ms. Cornblith. I do think there are fact issues here, and the motion for summary judgment is denied. Ms. Cornblith, please prepare an order and send it to me at my submission inbox. Do you have a piece of paper and a pen?
Yes. Is it the same one as before? I wrote it the last time.
455.submission@traviscountytx.gov. Put HO in the hearing order and clause number in the subject line. If your clients were here, but they're not, I would tell them, and I ask you to please communicate with them. Actually, I order you to. Please communicate with your clients that this is not a lot of money that's owed and that they could spend this all very easily litigating. I would like this case to go to mediation immediately. When could that occur, Ms. Cornblith, Ms. Salinas? I would like to put that in the order. When can we get this to a mediation?
I'm available after Thanksgiving to
Okay,
mediate whenever.
Ms. Salinas.
I agree that after Thanksgiving is doable.
Okay, here's what I want you all to do. I want you to I do order this case to mediation. You all select the mediators yourself. In fact, even if you go to the dispute resolution center, I'm fine. But I wanted like one order that denies the summary judgment, and I'd like that as soon as possible, Ms. Cornblith. And then I'd like the mediation date to be set And I would like that by noon tomorrow, okay? Or no, let's give you a little more time. Let's give you a little more time. Let's give you till Wednesday at 9, okay? You all get together, talk to a mediator, just because, look, they're gonna, any money they have, and I know they're mad, and I know that they wish this were different. Any money though that they spend right now, they could just be using to get this case resolved, okay?
Okay.
All right, you all, I'll be looking for both of those orders, Ms. Cornblith, on the summary judgment immediately, and then on the mediation by 9 o'clock on Wednesday. And you all pick the mediator. I'm just ordering it to mediation. I'm not ordering a mediator, okay?
All right. Thank you, Your
All
Honor.
right, thank you all. You may be excused. Have a happy Thanksgiving.
You too.
All right, that one's done. So that is a deny. And order to mediation. Mr. Thompson is the one who originally filed the motion to strike.
That's
So
correct, Your Honor.
let him start. Let's start with him. Tell me, Mr. Thompson.
Yes, Your Honor, we're here on a motion to strike a fleet safety expert designated by the plaintiff. As you're aware, I believe you said that you read some of the pleadings on file. This is a case that arises from a rear-end accident on the frontage road of I-35. It was a relatively minor accident with no police response.
Mhm.
Mr. Gonzalez, the defendant driver, was driving in the course and scope of his employment for Frito. He was driving a box truck type van. It's kind of hard to describe, but it's like something you could rent at the U-Haul. It is not something that you have to have a commercial driver's license for. It's
Okay.
a non-DOT vehicle.
Okay.
So he has a valid driver's license, to not have a CDL. It's not required to have a CDL.
Wow. Okay. Mhm.
The plaintiffs have designated an expert, a fleet safety expert, and we took his deposition. I've attached excerpts from his deposition as Exhibit A to the motion.
Mhm.
The expert's name is Paul Herbert, and essentially, Your Honor, we're contending that his opinions are unreliable, but also that he's not qualified. Mr. Herbert is a fleet safety expert that has been doing this since the 1990s.
Mhm.
And his background is that he graduated from high school. He did one semester at BYU. He then went to work as a state trooper in Nevada for a few years, for about 3 years. And then he was a truck driver, and he hasn't worked for a trucking company in 25 years. He's been doing this professional expert work. He testified, and this is in the motion, that he has testified something like 91 times for the plaintiff's attorney's office in the last 5 years.
Okay.
And he's a biased witness, is what I would argue, Your Honor, and also that he's not really qualified to talk about industry standards and federal regulations. He's not a lawyer, and he doesn't have an adequate background in some of these fields that he's talking about. Now, the second issue, which I think is more significant, is just that his opinions are not going to assist the fact finder in this case, and they're not really reliable. His main contention, I've nerded it down to about 3 things, Your Honor, that I think is what he's gonna say, right? He gives opinions about Mr. Gonzalez's failure to maintain speed and the fact that he failed a drug test, and states that that was a proximate cause of the accident. But he really has no basis for the claim that the failed drug test had anything to do with the accident, because there's no evidence of impairment.
Okay.
And you have to have evidence of impairment to be able to get proximate cause.
Okay.
And so without any evidence of that, and he admitted he can't testify that he was impaired at the time.
Okay.
So he gives opinions about, well, as a driver should make sure they maintain an assured clear distance. They need to maintain their speed. And he agreed that applies to every driver on the road. And so that's where we get into the issue of whether or not this is really expert testimony when a jury can kind of understand everyone should be able to, maintain an ensured clear distance and try not to, rear end people. It's pretty obvious. The second and third issues have to do with the claims against Frito-Lay, and he states that they should have randomly drug screened Mr. Gonzalez, and that they should have performed assessments of the driver each day. They should have assessed Mr. Gonzalez to see if he was intoxicated or impaired every day. And the issue is with it, when you have an expert, he needs to have some basis in a regulation or statute or industry standard. And Mr. Herbert can't point to any regulation that states that you have to randomly drug test a non-DOT driver. And he can't point to any statute that says that non-DOT company needs to screen non-DOT drivers every day before they get in the vehicle. And one of the examples that I gave in his deposition to him is, what about people that drive non-DOT vehicles, company vehicles home every day? Is the employer supposed to go home with that, when they come out every morning and check to make sure they aren't drinking? And it's just not a practical situation. And it's not something that's required. It's not industry standard. So there's he couldn't point to any companies that do this type of assessing of non-DOT drivers, and he couldn't point to any companies that do random drug screenings of non-DOT employees. So that's kind of the gist of it, Your Honor, is there's just no, he has no reliable grounds for some of these opinions. They all just are kind of, well, yeah, that would be great if every company could do it, but it's not based on any type of industry standard or statute.
Okay. All right. Very good. Thank you. Now, I believe that Ms. Wessendorf said she had a supplementation to this.
That's true, Your Honor. May I proceed?
You may.
Okay. And I don't know if it'll help at all if I could share my screen. Is that okay with you?
Yeah, that's very helpful, actually. The sharing of screens is a good idea.
Okay. Not that I have a very long presentation, because it's basically very similar to what Mr. Thompson said. But specifically, we represent the driver. And it's clear that this expert isn't a doctor. He's not a toxicologist. And there's a few things that he said in his deposition that we think are really important and on point to support our motion to exclude. Let's see here. And I can just show you the transcript is attached as an exhibit to our joinder and supplement. And this is some portions of the transcript. First of all, here at page 84, he testified he was not a toxicologist.
Right.
He testified he has not reviewed any data showing the amount of marijuana or cocaine that may have been in the driver's system on the day of the accident.
Right.
He's correct. And it's important here to recognize the driver was deposed. He stated that he had used some drugs at a party at least 2 days prior to the date that he was working. I think this accident was on a Monday, I believe. And he was at a party on the Saturday prior, according to his testimony. Also, the type of drug test that was done doesn't have any quantification of it. It doesn't state, how much of anything was in his system at the time that he was tested. And so moving forward on the same topic in this deposition with Mr. Herbert, he was asked about impairment. And the question was asked, you can't say with any reasonable certainty that Mr. Gonzalez was impaired at the time of the accident, correct? Answer, that's correct. Question, and that's because you don't have any training or other information to show what levels of substance were in the system at the time, right? And he said, well, I believe that's correct. There was some other testimony, obviously he wasn't on scene, no police were called to the scene, the plaintiff didn't testify that there was any sort of signs of impairment or anything like that. And so really from our standpoint, representing this driver, that's the main focus of our joinder and our supplement. Specifically, Your Honor, this is a case that we referenced.
Let me look. This is the way you're sharing the screen is very helpful, actually.
Okay.
So let me see, what is it you want me to look at here?
Sure. So I'm going to scroll up and show you this particular case. It's called Bedford versus Moore.
Yeah.
The case,
When you put the petition history on it, that's good too. I like that. It's helpful to me.
And let me scroll down here to show you the section that's relevant to our discussion here today. Sorry if I'm scrolling so quickly.
No, this is
a little
very
bit.
helpful.
So specifically in this case, the trial court had excluded evidence from a doctor expert, where this doctor was going to testify about potential impairment of a driver. So obviously already we've got a big difference here. This is a doctor in this Bedford case. Mr. Herbert's not even a doctor. And this is the appellate court explaining why it was not error to exclude that doctor's testimony about methamphetamine use as related to this particular accident. And here, I can obviously also send this if you like.
No, don't send. Just tell me what you want me to look at here. I'm looking at the part that says the court noted that evidence of the use of intoxicants is inadmissible as immaterial unless there's further evidence of negligence and improper conduct on the part of the user. That is, evidence of drug usage must provide some explanation for the negligence and improper conduct. However, this was not present under our facts because Dr. Drew could not tie the presence of methamphetamine in Moore's body to the impairment at the time of the accident, and therefore could not connect on the presence of the drug to causation. And what you're saying is here, there's no opinion on impairment, obviously. We don't even have evidence of impairment, so certainly there's no way to connect it to causation, right?
Right. And we wouldn't have the right type of expert if we wanted to connect it to causation.
Right.
Isn't a doctor or a toxicologist. Furthermore, we have this expert saying that he doesn't have evidence of impairment. So
right.
That's kind of it in a nutshell, Your Honor. And I'll stop sharing, and that's pretty much our addition to it.
All right. Thank you, Ms. Westendorf. All right, Mr. Sigmund, let me hear from you now, sir, on these topics.
Well, Your Honor, what I would say is this. This is a motor vehicle crash case, and Mr. Gonzalez was driving a delivery truck for rolling Frito-Lay sales. He crashed into Miss Benitez. He tested positive for marijuana and cocaine. Miss Benitez had verifiable injuries to her neck and back, and she also suffered a miscarriage about 8 days after the crash. Paul Herbert is an eminently qualified commercial motor vehicle safety and compliance expert. And I'll share my screen if you don't mind.
Sure, please do. That's helpful.
And let me know when you can see it.
I can't see it yet. Now I can see it. Go ahead.
Okay. So this is essentially Exhibit A that is attached to our response. And the first thing that I'll point to is that Mr. Herbert's got 40 years of experience in and around commercial vehicle operations and trucking.
Right.
And his areas of specialization, as you can see, are just numerous. His employment experience includes everything from being a highway patrol officer to, obviously, he manages his own practice that involves safety issues in trucking. But he's also got a lot of experience in training. He actually was a driver himself.
Right.
And he's been doing this for years and years and years. So I think that the contention that he brings nothing to the table, which is essentially what is being argued by the defendants, if you look at their motion, they say in quotes, he brings nothing to the table to assist the jury's determination. That's just patently false. I mean, if you look at the areas of specialized training, it touches on just about everything that's relevant or even potentially relevant in this case. Driver training programs, motor fleet safety programs, et cetera, et cetera. And then, of course, motor fleet safety. You can see where my cursor is moving, hopefully not too fast. And just all of these different areas where he has, given training, he's got experience over the course, again, of his 40 years.
Mhm.
So I think that that argument falls flat on its face. And then as far as, and in our response, we bring out the fact that Texas courts have consistently recognized fleet safety as a legitimate field of expertise with established methodologies. All throughout his report, which is also a part of Exhibit A, and this is the report, he makes reference to a variety of different sources that he touches and deals with. He talks about the Texas Driver Handbook. He talks about the National Highways Traffic Safety Administration standards. He talks about the Federal Motor Carrier Safety Administration standards, et cetera, et cetera. And then I think earlier we talked about what type of vehicle Mr. Gonzalez was driving. Here's a picture of it. So this is the type of vehicle that he was operating when he crashed into Miss Benitez's car. And, one of the things that keeps coming up is, and no disrespect to opposing counsel, but they kind of gloss over the fact that he was, that he tested positive for drugs and sort of the whole impairment issue. But the reality is that, yeah, there is no quantification by a toxicologist about the drugs in his system, but there's also no evidence that he wasn't impaired at the time. Absolutely none. There's not a shred of evidence that he was not actually impaired that day. And the reality is that the import of Paul Herbert's testimony is that he can help a jury understand, and he actually says this in the report, what the vast implications are of a system failure, because that's essentially what we have here thematically. We've got a young man that tested positive for drugs, that had access to a fleet delivery truck, and nobody checked in with him. Nobody gave him the once over before giving him the keys. He got into the vehicle, drove off, and was amongst the driving public on the day that he crashed into Ms. Benitez. And so an expert witness can certainly help a jury understand sort of the vast implications, if you will, of that order of operations and how that in itself constitutes a system failure. So to remove him from the case, and to say that, all the issues that are on the table are within the realm of a layperson's understanding is really doing him and the plaintiff a huge disservice given the facts of this case. And let's see, I'd like to draw your attention to I'm sorry, hold on. Pardon me, Judge.
That's okay.
Oh, in addition, he's also authored publications. He talks about his prior testimony. But here on page 7 of his report, he starts to talk about the various standards that have been violated by Mr. Gonzalez and also Frito Sales and by extension PepsiCo.
But it says
And
commercial fleet. I mean, so this is, all right, so commercial fleet is what you're focusing on. Apparently this driver didn't have a CDL, right? So that's what Mr. Thompson is talking about, right?
he didn't have a CDL, Your Honor, but the reality is that the truck that he was driving was a part of a fleet
Right.
owned and
All right,
operated by Rolling
all right.
Frito Sales.
All right, let's take a little time out here. Let's focus on the drug issue right now. I don't see that this individual is qualified to make any kind of opinion on the impairment. He may have at some point looked at a driver handbook on this, but I just don't see it. I think that
Well-
is a problem unless you can find something that says otherwise. The thing is this, we find, okay, so this individual's got cocaine, marijuana in his system, certainly not ideal for sure. But what we're not seeing is that there's any evidence that he was impaired at the time of the accident, or that the fact that this was in his system caused the accident. And this expert cannot speak to that. He does not have the qualifications. So that's kind of where I am with this, Mr. Sigmund.
Your Honor,
Um,
if I may,
Quickly, yeah.
is the impairment is a fact issue. And there's going to be testimony from my client as to his behavior
Okay,
and his
this
appearance.
individual will not testify on this, on drugs and alcohol. He is not qualified. That portion of his testimony is struck. You can get another expert who does have it. This one does not. So that's a no. Now, on the other issue, which Mr. Thompson is talking about, I will say that some of the things he complains about and is concerned about are typical topics for cross-examination. For instance, the number of times he's testified for plaintiff's firm. I think this expert has been in my court before, but I don't want to swear by it, but his name is very familiar. I might just have seen him somewhere else. But I do think he has the testimony to talk about fleet. So I'm going to not strike him on that portion, Mr. Sigmund. But if you're going to have him talk about, whether this driver, the drugs or alcohol that were found in his system, whether that was any part of the accident, he's not qualified to do that. So that he is struck on that issue. Okay. So I need you all to prepare an order for me. It's going to leave, I know Mr. Thompson's not happy. It's going to leave the fleet issues in, but take the drug and alcohol issues out. This guy cannot talk about it. He's not a doctor. He doesn't know. If you all want to talk about the impairment, then that's something else that you're going to need to get an expert on. But this individual, he just doesn't have the background for it. So that's what we're going to do today. All right. So I think Ms. Westendorf got the better end of some of this deal today. So I'm going to have her draft the order, and that's how we're going to cut that. Okay. So what I'm going to do, y'all, it's 2:44 in the afternoon. We're going to put you in a breakout room and have you all craft an order before you leave here today, because we don't want to keep bothering you all for orders. Okay. All right. So let's go in a breakout room. Let's put them in, work together. We're going to get back with you in 15 minutes. Ms. Dorina Bat, does that complete our docket for this afternoon?
Yes, it will.
All right. Very good. All right. So with that, let's let them go and confer a little bit.
Okay.
And work on an order for us, because no offense, guys, but these are the types of cases that really cause my staff a lot of headache as we try to get you all to focus and get your order to me. So you're going to have to work on it now. All right, Ms. Westendorf, you take lead on that one. We're going to put y'all in a breakout room, okay? And we'll come back to you. We're going to come back to you in 20 minutes. You got 20 minutes to work, okay? All right.
Okay, I've opened up a room for them. They should join it here.
Thank you. Thank you very much. All right, very good.